Right, good morning everyone. Welcome to Kuits, or welcome back to Kuits if you've not been before. So this morning, I'll keep my introduction fairly swift. My name is Kevin McKenna and I head up the employment team here at Kuits. This morning is all about the Employment Rights Bill. There's a lot in it, and we've got three great members of the team to talk you through it. So just the housekeeping. This is the reminder to either turn off your phone or down your phone if it's on. If you need to take calls, obviously everyone's in business, so feel free to do that outside the room. We're not expecting a fire drill. If there is one, then the stairs are just round the corner here, down the stairs, and then the muster point is outside the liquor store and pub over the road. Not open for another couple of hours. And toilets are back out by the lifts where you came in. Questions, if you can keep them to the end, that would be great so that we can get through all of the content. And then you've got some feedback forms, and if you can complete them at the end, that would be great. I think that's all of my housekeeping. And now I'll hand you over to Mark. I'm going to look like I'm leaving, but I'm going to then appear at the back of the room again. So I need to hear this as well.
We should really contact the liquor store to get sponsorship, because we do mention them quite a bit at these breakfast seminars. Okay, so this is us speakers today. So I'm going to be joined by my colleagues Claire, Treacy and James Howarth. And so this is a special on the Employment Rights Bill, which is probably the biggest reform of employment law in about 30 years. It really is huge. The bill was published on the 10th of October and sets out the plans that Labour referred to in their in the manifesto paper. It's all about enhancing employee rights, which if most people here today are an employer, then it may not be good listening over the next hour. It's also to fulfil the government's aims, which are to boost wages, reduce insecurity. So as it stands at the moment, there are about 1 million people on 0-hour contracts, and grow Britain's economy. The good news today, probably the only maybe good news, is the fact that a lot of the reforms are not going to come in until 2026. There are some consultations that have started. Most of the consultations will be in 2025, which will give an opportunity for employers to feed in on some of the key changes. Another just point to make is in relation to the impact assessment and economic analysis. So the Department of Trade and Business carried out some research in terms of the potential cost these measures would have to businesses in the UK, and the cost was put at £5 billion, which may sound a lot, but it's only an increase of about 0.04% on the wage roll within the UK. It's also forecast to be a 15% increase in claims in the through the channel of ACAS and also the employment tribunals. A lot of that will depend on, I suppose, the employer's willingness to comply with the new rules, and also the appetite from employees to challenge their rights. So today we're going to look at some the areas of where the key provisions sit. I'm going to look at unfair dismissal. James is going to have a look at the changes around fire and rehire, collective redundancy, and also sexual harassment and third-party harassment. Claire is going to look at the impact on employment contracts, family-friendly rights. I'm then going to come back in and talk about the kind of some of the changes around the tribunal rules, tribunal rights, and mention very briefly the enforcement body. And we're going to finish. James is just going to tell us what's not in the bill that we expected and that's been referred to in the manifesto. And also you've got some news as well of some of the amended proposals that were announced yesterday, which could well be quite seismic in terms of impacting the landscape. So probably the headline, change for employers and employment lawyers, and also I guess employees, is around unfair dismissal rights. As it stands at the moment, you need to have at least 2 years service to pursue an unfair dismissal claim. There are around about 9 million employees that fall into that category, So this really could be quite impactful. Now the qualifying period is about 53 years old. During that time it's fluctuated mostly between 12 and 24 months, depending on whether we've had a Labour or a Conservative government. It has dropped to 6 months before, but where it's not been is a day one right, which is what's going to happen as set out in the Employment Rights Bill. Some good news, it's not going to happen until probably autumn 2026. So you're going to have 18 months, 24 months to kind of prepare for this this change. What we don't know at the moment is how the rules will be interpreted with a lot of the changes within the Employment Rights Bill. We're waiting on secondary legislation which will essentially provide the more intricate detail. But what we know is that there will be some form of process in relation to an initial period of employment, or if you like, a statutory probationary period. It's going to be a lighter touch procedure. So I think that'll probably mean at least one meeting with the employee to explain the issues. What we also know is that any dismissal during the statutory probationary period will be based on reasons which are relevant or personal to the employee and not the employer. So it's likely that redundancy will not be a reason that you can use during that statutory probationary period. So we're probably looking at more performance conduct. Okay, we're expected to see a consultation paper next year on what that lighter touch procedure might look like. Yesterday the government announced that it's likely to be a period that is going to be between 3 and 9 months. So that'll be down to the consultation just to iron that out in terms of what that's going to look like. I think most employers would probably say, well, we need 9 months. They give us some flexibility to assess the employee's capability to do the job. Any dismissals outside that statutory probationary period will be subject to the unfair dismissal laws. Okay, so look, it is maybe 2 years off. That's not to say that you can't prepare for these changes. I think ultimately that probably will impact upon 2 points. First is your recruitment process. You probably need to tighten that up. Things like even looking at your recruitment supply terms. If you engage an external recruiter, then you might want to be looking at those terms to ensure that they align with the statutory probationary period. Another consideration is around actually, are your managers equipped to properly manage performance, particularly during that statutory probationary period. Another thing, and this is a loophole that might be closed off, but we might see more employers looking to engage temporary workers to try and get around some of the restrictions that this could pose on the recruitment practices. So that's unfair dismissal. James, you're going to talk about fire and rehire.
So the Employment Rights Bill has some provisions around fire and rehire. Government saying that the idea being that they want to tackle what they see as being one-sided flexibility. It's not the first time we've heard about fire and rehire this year. You might remember that the Conservatives introduced a statutory code of practice on dismissals and re-engagement back in July, just a few months ago. And what that code said is sets out a process that employers should follow if you're considering changing an employee's terms and conditions. If you fail to do that, they'll uplift compensation by up to 25%, as I say, for failing to follow the code. That will just sit alongside these new proposals. That's not going to change. So why is fire and rehire unpopular? Well, the government says it's essentially an unscrupulous practice, the idea being to bully employees to accepting changes in terms and conditions. I think that might be going a tiny bit too far, but from my perspective, it does tend to be done to change an employment contract to the worse for the employee. because otherwise the employee would probably accept it and consent to it rather than threatening fire and rehire or going through that process. Also, there's lots of negative press around fire and rehire. You might remember the P&O ferry scandal in 2022, where they, at very short notice, dismissed around 800 staff and then replaced them with much cheaper agency workers. So what are these new proposals? So they're proposing to make it automatically unfair to dismiss an employee for refusing to agree to a change in their terms and conditions. So terms and conditions is probably slightly wider than you think. It doesn't necessarily just mean a contract of employment. It would mean any contractual terms. So say you've got a contractual term in a staff handbook, say, or a side letter, that would be incorporated into this legislation. So yeah, automatically unfair, unless the employer can evidence a financial difficulty and demonstrate that the change could not reasonably be avoided. As you can see there, it says a very limited exception, and we know that because the accompanying note that sits with the Employment Rights Bill says it should only be used in exceptional circumstances. The change cannot just reduce that financial difficulty, it needs to entirely prevent it or eliminate it. So really the business is going to be fundamentally at risk of failing for you to be able to rely on that exemption. So yeah, really high threshold. So there's ongoing consultations on further measures, the first of which is to allow interim relief for an employee who is subject to an automatic unfair dismissal through fire and rehire. You might have heard of interim relief before. That is more commonly associated with whistleblowing. What that essentially allows is for, at the start of a tribunal process, a hearing to be scheduled at pretty short notice and a determination made as to whether that employee should be paid whilst the matter is litigated. And as you can imagine, tribunal cases take up to 18 months, probably take a bit longer once all this new legislation comes in. That's a very long time to be paying an employee who's presumably not working for you. So what can you do now, I suppose? Just don't fire and rehire? Maybe that's the easiest thing to say in the world, isn't it? It's obviously a bad practice anyway, and it's soon going to be essentially unlawful. If you want to change an employee's terms and conditions, consult with them. Follow the statutory code. Get the consent. If there's positive changes to it, really sell what that positive change is. If there's a negative element to it, well, maybe explain from the business perspective why that needs to be made and why, in the grand scheme of things, that's going to be beneficial for the employee. I would also look at your contractual terms at the moment. So look at your staff handbook, look at your contracts of employment, and be very comfortable with that offer, because obviously once this comes in, it's going to be very difficult to change what that offer is. And finally, maybe look at a variation clause in your contract of employment. So lots of contracts have little variation clauses. In incredibly limited circumstances, you might be able to rely on a really well-drafted variation clause to make some unilateral changes. Okay, I'm not going to tell you to go away and say, we can do what we want. Very, very limited, but it's something to maybe think about now. So the next thing I want to talk about is collective redundancies. So the government has pledged to strengthen employee redundancy rights and protections, and they're going to do this by changing the way we think about collective redundancies. So the current position, as it sets out on a very, very full slide, it says, where an employer has proposed redundancies of 20 or more employees at one establishment within a 90-day period, if that's the case, you need to consult with the elected representatives of those affected, and you need to notify the Secretary of State. In addition, if you're proposing to dismiss more than 100 employees, you need to ensure you collectively consult for at least 45 days before the first dismissal takes effect. If you don't do that, an employee is entitled to something known as a protective award, and that is currently capped at up to 90 days pay, and we'll come back to that in a minute. So you might know the Woolworths case back in 2014, quite a seminal case around redundancies, and that considered what an establishment is. And that case determined that an establishment is the local unit to which a worker is undertaking their duties. So what that meant from a Woolworths perspective is each individual store was that one establishment. So as you can imagine, what that means is to get to that 20 employee threshold is a lot harder because it's each individual store. Remember that. So the proposed position now moving forward in the Employment Rights Bill is that collective threshold is going to change. As opposed to being individual establishments, it's going to apply across the whole business. So as you can imagine, what that means is that threshold's going to be much easier to hit. It's going to really impact multi-site employers, because if you've got lots of different sites with lots of different individuals, you might have lots of low-level redundancies going on at different sites. Well, you need to have much better records now moving forward to amalgamate all those, because you might end up breaching that threshold. So again, there's a consultation ongoing moving forward. So they're considering allowing interim relief for an employee who is entitled to claim for a protective award. I mentioned that before. Obviously, interim relief is going to cost a lot more if you do not comply with this. They're also consulting on increasing that protective award. So currently, as I said, it's set at 90 days. They're either going to increase it to 180 days, so doubling it, a lot more expensive, or what they might do is remove the cap altogether and leave it to the discretion of tribunals as to what that compensation should be. So either way, it's going to be more expensive. And finally, what they're considering doing is, if you're dismissing more than 100 people, like I mentioned before, increasing that collective consultation period. So currently 45 days, they're considering increasing to 90 days. It just makes the whole process longer, more expensive, more difficult. So again, if those are implemented, it's just going to be much more expensive. And next, I'm going to talk about sexual and third-party harassment. So in October, the government introduced the Worker Protection Act 2023, and that set out a new duty on employers to take reasonable steps to prevent sexual harassment of employees in the course of their employment. And I know Kevin and Claire, hiding away at the back, talked about that at the last HR breakfast, so I can't do better than them, so I'm not going to talk about that in any way, but I will just mention the Employment Rights Bill. So that takes it further. And key there, I think you can just see it's highlighted reasonable steps. That's going to change to all reasonable steps. So you're going to have to take all reasonable steps to prevent sexual harassment in the workplace. And that was the originally envisaged position in the Worker Protection Act before the House of Lords changed it. So we're kind of going back to what was always proposed. Sounds like a fairly minor change, doesn't it? But it really isn't. So as before, you could have said, well, we took reasonable steps to prevent it. Now you need to say there was no other reasonable steps we could have taken. That's quite a big jump up, isn't it? It's also worth noting that that's a preventative duty. You have to make sure you take those steps before the complaint or so the act of harassment takes place. So you couldn't, for example, just say, well, we've got really robust disciplinary processes and this individual committed that act and then we dismiss them. That's obviously after the event. So what are reasonable steps? So risk assessments are going to be absolutely key. And I know we've been speaking to lots of retainer clients at the moment about what these risk assessments are. As a business, you need to be identifying what your bespoke risks are, because every business will have a different risk profile in terms of harassment. You need to be taking steps to think about how you mitigate those risks as well and codify that in a document. What follows from that is having a proper sexual harassment policy that's bespoke to your business. I know, I can't see Tyler at the back and Jake have been doing lots of sexual harassment policies for lots of clients recently. It's going to be really, really fundamental. Very much recommend you do that. What follows from that is having robust complaint and reporting procedures for harassment to make sure that employees know where they can make those complaints and raise those concerns. And finally, specific training. So some people in this room are probably fed up of hearing me speak because I've been doing training all the time for the last 2 weeks around this. It's incredibly important. You need to train your staff in terms of what this duty is, what's acceptable in the workplace, what isn't acceptable, and obviously referring to those policies, risk assessments, handbooks. So third-party harassment, this is another change under the Employment Rights Bill. So the previous Workers Protection Act already includes a duty to prevent sexual harassment by third parties, and that covered what we talked about before. But the Employment Rights Bill is going to go a bit further. So it's not just going to be sexual harassment that has to be prevented by an employer in the workplace. It's going to be all types of harassment related to those protected characteristics that relate to harassment. So that could be age, sex, disability. It's obviously widening that out quite a lot. And again, an employer will be liable unless you've taken all the reasonable steps to prevent that harassment. So reasonable steps will be similar to what I said before, but I would go a little bit further with something like this. I'd certainly be asking my third-party associates what they're doing in terms of preventing sexual harassment. It's not good enough just to say, well, they're subject to the same duty, so it's fine. I would ask those questions. I'd also think about maybe including contractual provisions in third-party supplier agreements, making it an obligation that they prevent sexual harassment as well. So the final thing is that sexual harassment is now very clearly going to be a protected disclosure. Probably was anyway, but for the avoidance of doubt, it's now going to be considered a protected disclosure. What that means is, protected disclosures, again, more commonly associated with whistleblowing, but what it means is, if somebody makes a protected disclosure, well then they can't be subject to a detriment, and they can't be subject to a dismissal, because that would be automatically unfair. And if that's the case, we've talked about before, interim relief, a sentence I've said more times today than I've probably said before, but yeah, interim relief applies. Also, it's a day one right. Also, that kind of compensation's uncapped, all those types of things. So yeah, really, really important it's treated properly and appropriately. The last thing I'll say before I hand over to Claire is what that means is a complaint of sexual harassment will not be able to be kept confidential in the settlement agreement. Not that you do that anyway, but it just makes it really, really clear that that's the type of stuff that cannot be kept confidential.
Morning everybody. So I'm going to talk about the government's attempt to ban what they would call exploitative 0-hour contracts. So the Labour manifesto basically said that they wanted to end one-sided flexibility. That was a big part of the employment section in the manifesto, and a big way of how they said they were going to do that was by banning 0-hour contracts. But the Employment Rights Bill, it doesn't actually go that far. There's not going to be an outright ban on 0-hour contracts. But what there is going to be is there'll be a new obligation on employers to offer what they call a guaranteed hours contract to qualifying workers to reflect the hours that they actually work during the relevant period. So we don't have all the detail of that yet, and that's quite similar to a lot of the provisions that Mark and James will speak about. A lot of it is subject to government consultation. But what we do know at the moment is that qualifying workers will be anybody who over a specific reference period, and at the moment the government are saying that's 12 weeks, that could change though, but over those 12 weeks regularly work more hours than that what their contract guarantees them. So if you have workers on 0-hour contracts, but actually the reality is that over the 12-week period they work around 10 hours a week, or you have workers on a contract which say only offers them a low number of hours, so about 5 hours a week for example, but again over that 12-week period they actually work around 10 hours a week, then in both of those situations you as a business will be under an obligation to offer them this guaranteed hours contract. We don't know exactly yet what it means to have to offer a guaranteed hours contract that reflects the hours that they work, but you can imagine it's probably going to be a case of working out what the average number of hours worked a week are over that 12-week period, and then having to offer them a contract which reflects the average hours worked each week. But again, that's something else that we wait to find out about. So as I said, we know the obligation applies to 0-hour contracts workers, but it also applies to those on a low hours contract. But the government haven't said yet what they consider to be a low hours contract. So I gave the example before of 5 hours a week if you have a contract that offers workers that amount of work a week. But it could be that they set that bar higher. It could be anything up to 10, 12 hours a week. We don't know that yet. So that's just going to obviously be, the higher they set it, the more difficult that's potentially going to be for employers. But the reason that they're doing that is because the government very much recognises that if they don't, and this just applies to 0-hour contract workers, then lots of businesses will basically just say to the staff, we'll put you on a 1 or a 2-hour contract a week, and then we don't have to offer this guaranteed hours contract. So it's basically to stop that potential loophole. So the obligation is very much to offer the worker the guaranteed hours contract. They don't have to accept it. Some might like the flexibility that their contract gives them, and that's fine. But you can imagine there's going to be a lot of workers that will want the stability, the financial stability that a guaranteed hours contract will give them. And from what we understand from the bill so far, the obligation to offer them this guaranteed hours contract is going to reoccur every 12 weeks. So if you have a worker that every 12 weeks works above the hours that they're actually contracted to, then it seems that you're going to have to re-offer them this guaranteed hours contract that actually reflects the hours that they do. So that's even if they say no, even if they say, no, I don't want it, it seems like you're going to have to carry on offering it them. So it is quite the administrative burden, to say the least, on businesses if you do use these type of workers. And then, as it says on the slide, if you don't, there will be the ability for workers to pursue an employment tribunal claim, and the compensation, we understand at the moment, will be based on what they would have earned if you'd offered them the guaranteed hours contract. So in terms of exceptions, there's only really a limited exception at the moment if the contract is genuinely temporary. So if you have a specific event, you're putting on, a specific event that you need a member of staff for, or a few members of staff for, then it seems that would not require you to then offer them a guaranteed hours contract based on the hours that they worked for that specific event. And I think it's arguable, potentially, that will extend to predictable seasonal fluctuations in work. So obviously at this time of year, retail, hospitality, it's going to be incredibly busy. You're going to know each year that you're going to have more hours for your staff, and that's then going to drop off in the new year. So it looks at the moment like the legislation won't require you to then offer a guaranteed hours contract based on the hours they did over that predictably busy period. But that's the only exception at the moment. They are consulting, or they will be consulting, I should say, the government, to see if there should be any other exceptions. So it could be that becomes wider, or that there are different exceptions. But what the government have been very clear on is that there's not going to be specific sectors that will be excluded from this. So they're not going to say, for example, the leisure sector, this guaranteed hours obligation won't apply to you. Then the only other thing just to mention on this slide is the bottom bullet point where it says consultation open for the obligation to offer agency workers this. So again, the government don't want to create a loophole where businesses say, I'm not going to use 0 hours or low hour contract workers anymore, we'll just use agency workers. They're very set that this will also apply to agency workers. So at the moment, the consultation, and it is open now, is about whether it should be the agency or the hiring business that has to offer the guaranteed hours contract to the agency workers. So wait and see what the outcome of that is. So when it comes into force, it's obviously going to be quite big changes for businesses that use these type of workers, and unfortunately that isn't the only change for these type of workers. So just looking at the first bullet point on this slide, this applies both to the workers I was just talking about, but also shift workers who don't know their shifts in advance. And the additional obligation or right that they're going to have is to reasonable notice of their shifts. So that's reasonable notice of a shift, as well as any change to a shift and to a cancelled shift. So obviously the key with this one is going to be, well, what is reasonable notice? And the government haven't said that yet, probably not surprising. What they have said is that they're going to state how much notice should be presumed reasonable. And if you give less notice than whatever they say is presumed reasonable, you'll be assumed not to have given reasonable notice, unless, as a business, you can explain or justify that it was reasonable according to a set of factors that will be set by the government in legislation. So we don't know what those factors are yet as well. That's something else that's to come. But just speculating, it could be things such as, if you have a lot of people calling sick quite last minute and you have to then ask somebody to come in for a shift and you couldn't give them any more notice than you did give them, potentially that will be a factor that would be considered. But as I said, we need to wait and see what those factors are, and also what the presumed reasonable notice is. But what we do know is that when it comes in, employees again will be able to bring a tribunal claim if you don't give reasonable notice of the shift, change to a shift, or a cancelled shift. And then just moving to the second bullet point, which kind of ties in with the first, but again, in relation to the same workers I was talking about, if you cancel a shift, move a shift, or cut a shift short at short notice, then as a business, as the employer, you will have to make a payment to the individual. So the key with this one is obviously going to be understanding what is short notice, and obviously you'll want to know what the payment is. So now we don't know what short notice is. All we know is that it's not going to be less than a week. So say the government set it at a week. If you give less notice than that, you'll be deemed to have given short notice and therefore liable to make a payment to your worker. In terms of the payment, all we know so far is that it's going to be proportionate to the amount of notice that you give. So presumably if you give less notice, the payment will be higher. The more notice you give, presumably the payment won't be quite as much. And then finally, just to say on this bombshell of shift workers and 0 hours workers, is that the consultation I mentioned before that's already open is also considering how these things apply to agency workers. So should it be the agency or the hiring business that is responsible for giving the reasonable notice and responsible for making the payment? So wait and see obviously what the outcome of that is. So that was all I was going to say on, it's quite a lot, but that is all stuff. So I'll just move on now to look at the family-friendly rights provisions that have been set out in the Employment Rights Bill. So starting with flexible working. So the government had said that flexible working, or they were going to try and make flexible working the default right for all, but the reality is they've not done that, and they don't seem to be intending to do that. There's actually not many changes to the flexible working request regime set out in the Employment Rights Bill. The only real change is that, as it says on the slide, there'll be more onus on the business to explain why they're refusing a flexible working request. So if you've ever dealt with them before, you'll know that there's 8 business reasons or business grounds as to why or how you can reject a flexible working request. They're not changing, they're going to be exactly the same. But when the Employment Rights Bill comes into force, it won't be enough just to say we're rejecting it on that ground. You'll have to go further to explain why you're rejecting it on that ground. I think the reality is a lot of businesses would do that anyway out of courtesy and obviously to explain the decision. So that's why I say I don't think that's a massive change at all. The second one, paternity and parental leave, both will become day one rights, which means that as soon as an employee is employed by you, they will be entitled to take those 2 types of leave. Currently, paternity leave, the employee has to be employed by you for 26 weeks at the point of 15th week before their baby is due. And in the case of parental leave, they need to have been employed by you for a year before they can take that leave. But as I say, both of those things are changing. That just really brings it in line with maternity leave and adoption leave, which are already day one rights. Strangely, it doesn't change shared parental leave, so that isn't a day one right. I'm not really sure why that one's been missed out. But yeah, that's just one to bear in mind that will be changing. And then thirdly, bereavement leave. So at the moment, there's no statutory right to bereavement leave unless, in a very sad situation, if a parent was to lose a child under the age of 18, there is a statutory right. But for everybody else, there isn't. But I know a lot of businesses would offer compassionate leave anyway. But what this is saying, when it comes into force, is that you will have to offer bereavement leave to all employees that'll be eligible for it. What we don't know yet is what relationship the employee will have to have with the person that's passed away. So whether it will be limited just to immediate family or whether it might extend to extended family, aunties and uncles. We do know though that it will be a day one right, like I mentioned for paternity and parental leave, and that it will be for at least 1 week. And then the final one to mention is the government's intention basically to make it unlawful for employers to dismiss women that are pregnant, that are on maternity leave or that have returned from maternity leave in the last 6 months. That 6 months time frame isn't definite yet, that is subject to change, but that's what they're saying at the moment. And they're saying it will be unlawful to dismiss them for any reason unless there's very specific circumstances. We don't know what the specific circumstances are yet. You would imagine if there's an example of gross misconduct, that would be okay. But we wait and see what the government end up saying on that one. So that was everything I was going to mention. And Mark, thank you.
Claire.
Thanks.
So another part of the Employment Rights Bill relates to trade unions. Does anyone here deal with trade unions in their business? Okay, one. So the goal of this essentially is to use the trade unions to help, if you like, police and safeguard employee rights in the workplace. So it's strengthening the bargaining rights, and ultimately that's there to protect job security, inequality, discrimination. So Labour is very keen, and obviously the trade unions have helped Labour in terms of their election, very keen that actually trade unions are pushed forward and given greater rights, because they feel that the trade unions are best placed to safeguard employee rights in the workplace. So in terms of the changes we're likely to see, again, it's going to be 2026 at the earliest, might even be later. It's going to start with the contract. So there'll now be an obligation on employers to tell their staff that they're entitled to join a trade union. So that'll be that form part of the Section 1 Statement of Particulars. So at the moment, the employers are required to tell employees about certain things. So this will be another ingredient of that. The penalty at the moment is quite low. It's up to 4 weeks' pay, which is around capped at 2,800. So it's not going to be a huge risk if you fail to do that. But I think as we get into 2026, I think more employers should get into the habit of actually building this into their statement of particulars, their contract of employment. Where there is going to be a change is in relation to access rights to the workplace. As it stands at the moment, there's no general right for trade unions to access the workplace for the purposes of recruitment for membership or for organising industrial action. That is going to change on as set out in the bill. There's going to be greater access rights, and that's to represent, recruit, organise workers and to facilitate collective bargaining. Importantly, the bill doesn't say it will be to organise industrial action. Okay, so as it stands at the moment, employers can agree to trade unions coming in. I guess many might be kind of reticent to that anyway. Or potentially that they may be required to under an order from the Central Arbitration Committee. But I think, judging by it, looks like most people in this room don't necessarily have trade union recognition within their workplaces. So in terms of, again, subject to consultation, but it's likely that there will be some form of negotiation around the terms of access. There'll be an access agreement that the parties, the employer and the trade union, will be required to agree on. If those terms can't be agreed on, the trade union has the right to make an application to the Central Arbitration Committee to ensure and for an order that the employer actually allows access to the workplace. Okay, so I think trade unions are going to feel this is going to really help them in terms of driving forward their recruitment. Ultimately, they're a business themselves. They want to increase their membership. They want to bring that money in, and that's going to fund other activities. Another change which is forecast is in relation to statutory recognition. So at the moment, there has to be 10% of the proposed bargaining unit are trade union members. That's likely to be diluted down to potentially around 2% is what's being discussed. Again, trade unions have the right to apply to the Central Arbitration Committee to enforce recognition within the workplace. There'll be increased protections for time off and extra provision for facility for trade union officials. We're also going to see increased protection against blacklisting. So blacklisting is where you essentially deprive somebody of a job or an employment benefit because of the fact that they are involved in trade union activities. So we're going to see that extended beyond the employer. It's going to be other bodies other than employers and employment agencies. Expected to see some changes in relation to ballots and industrial action. There's going to be relaxation of the turnout and support thresholds. So they're going to remove the current 40% threshold, and it's simply going to be a majority to agree to activities. And there's going to be an increased protection for those that participate in industrial action. So, under the new laws, there's going to be protection for workers against detriment short of dismissal. That's a bit of a gap actually under current laws, that you can, certainly there's protection against dismissal, but there's not protection against detriment. So detriment could be, again, where you deprive somebody of maybe a promotion or other benefits within the employment contract because they're involved in industrial action or involved in trade union activities. And another key part of this is a few years ago, the Conservatives over the last 10 or so years have tried to just really water down trade union rights, in particular in relation to minimum service levels, which was something 2 years ago that Conservatives were very keen to push through. So that's going to be repealed. So employer won't be able to put in place a minimum service level during any strike action. So it definitely changes afoot. In terms of, well, how is this going to affect us as a business? I think it's likely that the trade unions are going to target the larger employers first. So it could be a few years before this kind of works its way to your business. Another thing to think about is, well, actually, why do people join trade unions in the first place? And I think a lot of people feel that it gives them a voice in the workplace. So that might be something worth considering. I actually do feel confident that your staff have the right to speak up. So you might want to, if you don't already have any in place, you might want to consider employee representative groups or committees. So giving your staff an opportunity to get together as a collective and to raise issues in the workplace. So that might be something to think about in 2025. Okay, so that's, I think there's going to be a lot more to come on this, and next year we'll be doing seminars on enhancement to trade union rights and how this might impact your business. So that's kind of an overview of what we know, what's been announced to date under the Employment Rights Bill. Quickly mentioned there's going to be a new enforcement body as well. Again, it's going to be no earlier than 2026. A fair work is for enforcing a wide range of employment rights. The areas that are included will include holiday pay, statutory sick pay, employment agencies, national minimum wage, and modern slavery. The powers that will include are the ability to require a person, an employer, to provide specified information or documents. So you could get an order to disclose holiday records or holiday pay or national minimum wage payments. There will be an ability for an enforcement officer to enter your premises and examine documents. Now, I'm not sure whether that's going to consist of a dawn raid, but what it's trying to do is just give the enforcement body stronger rights to really put pressure on the employer to comply with these rules. The other thing, it's not on the slides, but it's likely that Fair Work Agency will be able to order that somebody representing the employer or the business attends a meeting to explain why perhaps there's been an underpayment in national minimum wage, or they've failed to pay holiday pay. So more to come on that, but it's just to kind of put that on your radar. So we're going to finish with James is going to talk about things that are not in the bill, which we're maybe a little surprised about, fair to say, because they were referred to in the manifesto. And James, you're also going to mention what was announced yesterday in relation to limitation of claims.
So as Mark mentioned, these things weren't contained in the Employment Rights Bill, but things that you probably remember that Labour campaigned on as part of the election campaign. So the first of which is a right to switch off. So Labour wants to introduce a right that prevents employees from being contacted outside of their contracted working hours, except in exceptional circumstances. So again, we don't know exactly how they're going to do this, but what they said is they're not going to introduce new legislation to codify that. What they would like to do is introduce another statutory code of practice, setting out what is acceptable in terms of switching off. And what the hope is that employers will then follow that statutory code of practice and introduce policies that adhere to it as well. I believe, and speaking to Mark yesterday, I think they do that in Ireland already, so it's kind of similar to that kind of regime, that you're following something rather than kind of hard legislation that says what you can and can't do. We all again might remember about moving towards a single status of worker. That was another big pledge as part of the Labour manifesto. Who would have thought that's an incredibly difficult thing to do in 100 days? Like, almost impossible, you would say. And I think they've obviously found that to be the case as well. So yeah, that's not contained, there's no legislation contained in the Employment Rights Bill that makes that happen. But there's definitely a commitment from Labour to move toward that single status. So self-employed worker, not self-employed worker and employee as well. And finally, they're looking into changes to parental and carers leave. I know Claire's mentioned about parental leave. This is more in terms of changing the payments that are being made. They're going to fully consult in terms of how that's going to impact the system. And they're also considering introducing paid carers leave as well. Again, subject to consultation. Don't know what that's going to look like yet. And I'm going to say finally, but actually I've got something else after the next thing, so I'll say finally. The King's Speech has also announced a new Equality, Race and Disability Bill, which introduces new requirements for businesses over 250 employees. The requirement is to publish equality action plans. So what these plans are going to involve is you showing demonstrable steps that the business has taken to improve gender equality, steps that are being taken to address the gender pay gap, and also, for example, steps to support employees going through the menopause. So that's going to be something that has to be published and reviewed annually. So yeah, if you've got more than 250 employees, it's a new obligation on you. And finally, this is so hot off the press that we've not even managed to update our slides because it only came out yesterday and Mark's mentioned it. So the Employment Rights Bill was obviously a very large document, lots of bits and pieces in there. We've talked about that for the last hour or so. But there's some things that were missing, things that we kind of expected as well. So what the government has done is published an amendment paper that came in yesterday, and that lists a couple of extra changes that are being made. I don't think we're going to speak about a lot of those because some are somewhat minor. Also gives us more content to talk about maybe next time or an extra e-bulletin. But one thing I'm going to talk about very, very briefly, because it's a really big change, is they're going to change the time limits for tribunal claims. So what the proposal is, as we currently know, most tribunal claims need to be presented before a tribunal within 3 months of the date of dismissal, the date of the act of what they're complaining about, depending on what type of claim. It tends to be 3 months, subject to an extension through ACAS conciliation. We all kind of know that. What they're proposing to do is to extend that 3-month period to 6 months. So a much longer period that people can bring claims. Again, I don't think that's trivial. I was going to say that seems like a trivial change. I don't think it does seem like a trivial change. It's quite a big change, isn't it? It means more claims in the tribunal. As an employer, sometimes you might get to 3 months and think, I'm done with that, it's not a problem. It's a lot longer period of now than now. So I think that's going to be a really fundamental change in terms of the tribunal system. But yeah, maybe we'll talk about that more in a bit more detail. We've got a bit more time as well. So that is me done. And on that bombshell, I'm going to hand back to Mark, I think.
Okay. We've got some time for questions. Has anyone got any questions of the content we've discussed?
Just on the 0 hours, so we don't have 0 hours, we have 39-hour contracts, but we offer overtime quite a lot. So if, for example, in that 12 weeks they regularly do overtime, does that mean a contract review and to change it to match their overtime?
They haven't, I don't know is the answer to that. I think it's unlikely because none of the commentary seems to be that it's focusing on those type of situations. It's people more on the 0 hours or the low hour contracts that are mentioned.
Yeah, I've got a question on a similar thing.
Yeah.
We've got a bar in Manchester, we've got a lot of students, give them a contract, and there's 0 hour contracts where we are. So now we're 20 hours, and now we're 26, and now we're 30, and then 1 week they want to have Saturday off. Then they've got dissertation coming up, can I go down to one shift? No problem, other people might step in. This just sounds like an administrative nightmare when we have to permanently change the contract every time they want to move things. Is that how I'm reading it?
They don't have to accept it, so they could, if it doesn't work for them, they don't have to accept this guaranteed hours contract that you would have to offer them. So in that situation, you might be okay if they're, if it doesn't work for them. So I guess it might be a communication thing as to what it would mean for them if they do accept it.
Any other questions? But by the way, the team will be around afterwards as well if you want to speak more discreetly. Sorry.
We recruit quite a lot of temporary fixed term contracts, especially over our Christmas period. So with the day one rights, how does it apply to fixed term contracts? Will it still be unfair dismissal when we end the fixed term contract?
Possibly. So if they're employees, then they'll be entitled to day one rights. There'll be that statutory probationary period, which will be between 3 to 9 months. So it depends. How long would your fixed term contract be for what?
Probably
It varies.
6 months, but sometimes you might have a 12-month contract with maternity cover, for example.
Right. Okay. So say it's 12 months. So you can. There's a suggestion you will be able to increase your contractual notice period. So I think they will accommodate fixed term contracts. I think if you said is 9 months as a statutory probationary period, you have that period after 9 months where employee will accrue essentially unfair dismissal rights. So if you then dismiss 3 months later as a non-renewal of a fixed term, that potentially could be subject to assessment under these rules. I think you have a fair reason, because if the expectation is that it was there for a specified period, employees coming back from, say, maternity leave, then there's no role for them. Then I think that'll give you, I don't think that'll change much, put it that way. Anything else?